Due to a technical failure, the beginning of our panel, Civil Pleading Standards After Iqbal, was not recorded. Our moderator, Professor Robin Effron of Brooklyn Law School, introduced our 4 participants. They included Professor Suja Thomas of the University of Illinois College of Law, Professor Adam Steinman of the University of Cincinnati College of Law, Professor Stephen Burbank of the University of Pennsylvania Law School, and Professor Suzanna Sherry of Vanderbilt Law School. Our recording begins partway through Professor Thomas's remarks.
So if you look at then the motion to dismiss, this new motion to dismiss, and compare it to the demurrer of the pleadings and the demurrer of evidence, I say that you don't really have a connect. That under this new motion to dismiss, there's this sort of plausibility, sufficiency analysis, whereas under the motion, the demurrer of the pleadings and demurrer of the evidence, you actually accepted the facts and the conclusions as true, including that which was implausible. The next thing I do in the paper is I look at the substance of the common law and compare the substance of the common law to the new motion to dismiss, because the Supreme Court has said we have to look at not just the individual procedures, we have to look at the substance. And even though the Supreme Court itself hasn't derived that substance, as I said, I did some work here too. So in a previous paper, I derived these core principles. And so under the first core principle, we have one party could admit the allegations or the conclusions of the evidence of the other party, or the parties could leave the determination of the facts to the jury. A court itself never decided the case without a determination of the facts by the parties or the jury, however improbable the evidence was. And so that's sort of what you see with both the demurrer of the evidence and demurrer of the pleadings, that a judge can't actually determine the actual case unless you admit the facts and the conclusions of the pleadings or the actual evidence that was presented, including that which was implausible. Now, the second slide, I think, says a lot about the core principles of the common law. Second, only after parties presented evidence at the trial and only after jury rendered a verdict would a court ever determine whether the evidence was sufficient to support a jury verdict. Where the court decided the evidence was insufficient, the court would order a new trial. Another jury would actually determine the facts and decide which party won. And so under the common law, a procedure that I didn't mention, there was another procedure called the new trial, a procedure that we have now. And there was a sufficiency of the evidence determination there, but there had to be another trial. Once after there was actually a trial, there was a sufficiency, there could be a sufficiency of the evidence determination, but the court would order a new trial. And so these are sort of the two, I would say right now, core principles of the common law. And then I think if you look at and you compare the common law to the new motion to dismiss, that again you see that there's a disconnect. That only under the common law could there be some kind of sufficiency, and I would say similar to plausibility analysis, if there had been a trial already, and if that was the case, it had to be sent to a new trial. So on the basis of looking at the different procedures under the common law, and the demurrer of the pleadings and the demurrer of the evidence were two of the procedures, and I looked at a number of other ones, as well as the substance of the common law, I concluded that the motion to dismiss was unconstitutional. And the last thing I'll just sort of say before I turn it over to Steve is that if the motion to dismiss required the acceptance of facts and inferences as true, I say that then the motion to dismiss would be constitutional, which is what I said in my sort of previous paper before the standard was changed. And this was the motion to dismiss under Conley versus Gibson. Thanks.
I'm going to talk about a somewhat different aspect of Twombly and Iqbal, namely getting rid of them. In early December, I testified before the Senate Judiciary Committee at a hearing that was called to address the important question whether Twombly and Iqbal are denying Americans access to court. And although I praised Senator Specter for his early action in introducing a bill to overrule the court's decisions, thus signaling concern to the bench, the bar, and the public, and stimulating interest in debate, I argued in favor of an alternative that I included as an appendix to my prepared statement. Essentially, the alternative would restore the law to what it was on May 20th, 2007, which is the day before the first of these two cases was decided. I took inspiration in that from a provision in the 1991 Civil Rights Act that is very similar, and I also took inspiration from the dialogue that Specter's bill and a House bill that was subsequently introduced had stimulated. The alternative that I proposed reflects my view that first, the Court's decisions in Twombly and Iqbal resulted from a process that for this purpose was both illegitimate and inadequate. Second, although legislation is a legitimate process for amending the Federal Rules of Civil Procedure, the Enabling Act process is usually to be preferred and is preferable in this instance at least as a basis for ultimate legislative judgment. And third, nonetheless, legislative action is required now to prevent irreparable injury pending the completion of the Enabling Act process. Now, the process leading to Twombly and Iqbal, adjudication under Article 3, and hence the decisions themselves, were illegitimate because they effected consequential changes to the Federal Rules of Civil Procedure without affording Congress the opportunity to review and, if necessary, to block the new policy choices contained in those decisions before they became effective. I usually avoid the term judicial activism because, in my experience, people who use it do so as a label to describe decisions that they don't like without reference to an objective standard. Twombly and particularly Iqbal are examples of judicial activism, I contend, according to an objective standard, namely that's contained in the Enabling Act and in the Court's own previous decisions distinguishing judicial interpretation from judicial amendment of the Federal Rules. For the Court has told us that, quote, we are bound to follow a Federal Rule as we understood it upon its adoption, and we are not free to alter it except through the process prescribed by Congress in the Rules Enabling Act, end quote. Twombly and Iqbal's defenders must pretend that, quote, interpretation, end quote, is a process sufficiently capacious to accommodate, first, the abandonment of the system of notice pleading that the drafters of the original Federal Rules intended, that Congress and the Bar were told in 1938 had been implemented in the Federal Rules, and that the Supreme Court embraced as early as 1947. Second, its replacement by a system of complaint parsing that is hard, if not impossible, to distinguish from the complaint parsing under code pleading that the drafters of the Federal Rules explicitly rejected. Third, a wholly new general requirement of plausibility. And fourth, the demonstrable rewriting of Rule 9b. I understand that the difference between interpretation and judicial lawmaking is one of degree rather than kind, but here the degree of separation approaches 180. Comparing the role that those who wrote the Federal Rules envisioned for pleading and what they thought could fairly be demanded of plaintiffs filing complaints with the new world celebrated by Twombly and Iqbal's defenders leaves no doubt that the Court in those cases ignored previous acknowledgments that it has, quote, no power to rewrite the rules by judicial interpretation, end quote. Even before Iqbal, Judges Posner and Easterbrook and Professor Epstein, who are not known for bleeding hearts, appeared to agree. One can only wonder at the spectacle of justices who deride a living Constitution enthusiastically embracing living Federal rules. From this perspective, the legislation I favor would bring back the Federal Rules in exile. The process, and hence the decisions, were inadequate as opposed to illegitimate because adjudication did not give the Court, and the justices otherwise lacked, the information, experience, and breadth of perspectives that are necessary for wise prospective lawmaking about matters as fundamental as access to court and private enforcement of public law. Consider in that regard the Twombly Court's discussion of the costs of discovery. Eschewing any reference to systematic as opposed to anecdotal data, the majority relied to a great extent on an article by Judge Easterbrook that is heavy on theory and light on facts. Not only was that article's analysis predicated on a law and economics model of so-called impositional discovery, it was published in 1989, before substantial changes to the discovery rules in 1993, 2000, and 2006, changes that the Twombly Court ignored. As I observed about the Seventh Circuit's attempt to turn Rule 11 into a fee-shifting statute in the 1980s, theory is an irresponsible basis for lawmaking about something as important as access to court. And it is especially irresponsible when the lawmaking involves judicial amendment of a rule. Finally, in this aspect, quite apart from systematic empirical research, consideration of many of the policy questions implicated in Twombly and Iqbal would have benefited from a base of experience with federal trial court litigation broader than that possessed by the members of the Supreme Court, almost all of which predated Justice Stevens' appointment in 1975. Congress does not suffer from the deficits in democratic accountability of the Court's decisions in Twombly and Iqbal. Rather than itself running the risk of legislating pleading law on the basis of incomplete information and partial perspectives, however, Congress should insist on respect for the process that it has prescribed in the Enabling Act as amended in delegating legislative power to the court to make prospective supervisory rules. Some legislation, I believe, however, is necessary now to forestall the damage that the court's decisions could do in the 3 to 4 years that it will take the Judicial Conference's Rules Committees properly to address the issues under the Enabling Act process. Of course, we don't know yet. We don't have enough knowledge about the impact of Twombly and Iqbal to state with confidence that they will cause a radical change in litigation behavior or the results of litigation. Still, I include in an appendix to my prepared statement a sample of cases, and there are a lot of them, in which the courts have either suggested or explicitly stated that complaints that they were dismissing would not have been dismissed under prior law. And early empirical work, I'm referring in particular to a study by Professor Patricia Hattemeyer, suggests that Twombly and Iqbal have had a disproportionately adverse impact on the usual victims of procedural reform, namely civil rights plaintiffs. Hattemeyer's study, is, to be sure, has its problems. It suffers from the biases of all empirical work that is based on published decisions. But I'm less concerned about that in this context than I am normally, because in my view the relevant question should be who should bear the risk of irreparable injury as a result of the Supreme Court's improvident decisions. In my view, it should not be those usual victims of procedural reform, and it should not be the beneficiaries, or I should say the intended beneficiaries, of federal statutes that Congress designed to be enforced through private civil litigation. Finally, although the approach taken in my proposed substitute amendment would necessarily yield some uncertainty and inconsistency, they could not, in my view, be any greater than, if as great as, the uncertainty and inconsistency that new statutory standards would engender, or that Iqbal's capricious complaint parsing and privileging of judicial experience and common sense have already created. Most risible of all the arguments that I have heard against the status quo approach is that it will, quote, guarantee inconsistency, end quote, as if Twombly and Iqbal will bring about consistency. I prefer the devil I know to the devil I do not know, at least until such time as there has been a thorough, open, and democratically accountable lawmaking process that justifies installing a new prince of the nether regions.